Order in the court!
I'm Claire Marshall, tuning in on November 4th, 1991, to issue the drug policy implemented by the Vernonia School District to be deemed unconstitutional due to its violation of the United States Constitution.
From 1988 through 1989, officials have begun to notice a rise in drug use among the students of the Vernonia School District. Many disciplinary problems have arisen directly related to drug usage, where student athletes are often the worst offenders. In concern of the safety of their students, the district initiated a random drug testing program. In order to participate in interscholastic athletics, students and their parents are required to sign a form agreeing to the testing.
Very interesting. Each athlete shall be tested at the start of the season, and 10% of the athletes will be selected randomly every week to provide a urine sample. If a student sample tests negative, they will resume their current sport. However, if a student sample tests positive, the student will either receive counseling and submit to 6 weekly drug tests, or will be forced to sit out the remainder of that current season as well as the following.
James Acton, a 7th grader attending Washington Grade Middle School in Vernonia, decided to play football the fall season of 1991. When the student and his parents were asked to sign a sheet consenting to the drug test, both refused. Wayne and Judy Acton believe this is a violation of James's privacy, and therefore the school refuses to allow James to play football.
Well, the Acton's complaint here states that the random drug test protocol is a violation of James's right under the 4th and 14th Amendment to the United States Constitution. Additionally, the complaint asks the court not to allow the school from interfering with James's participation in interscholastic athletic programs. Now, the 4th Amendment of the United States Constitution protects citizens from searches and seizures. The purpose of this amendment is to uphold the privacy of individuals against invasions from the government and its officials. Additionally, the 4th Amendment requires that searches meet a reasonable standard and are completely necessary. The 14th Amendment of the United States Constitution extends searches and seizures by state officers, including public school officials. However, this extension does not disregard the fact that a search must be reasonable.
Although drug testing is a search recognized in the 4th Amendment, warrantless searches are legal unless the person agrees to the search. James and his parents did not agree to the search and therefore shall not be forced to allow it. Vernonia's drug testing policy may justify individualized testing, yet it does not account for random testing amongst the entire student population. This procedure is unreasonable because it tests all student athletes rather than those who are under suspicion of drug use. Therefore, it violates the 4th Amendment because it is not a reasonable search.
Vernonia's drug testing policy was a really significant invasion of privacy. Students were taken from class and asked to give a urine sample while a teacher stood nearby in the restroom.
All human beings, or student athletes in this case, have as much of an expectation of privacy as any other beings, despite the fact that students are compelled to attend school and participate in athletics. The drug testing policy should not reduce their privacy.
Furthermore, drug tests have been adopted in many circumstances such as the federal agencies in order to prevent extreme accidents and injuries. The district's policies were initiated to ultimately reduce drug use among students, prevent unnecessary athletic injuries, and to improve discipline, which simply do not compare to the severity of other policies. Lastly, evidence reveals that only some students are actually using drugs, despite the extensive belief that the majority of the students are. Only one teacher testified that she had actually seen a student using drugs, followed by secondhand reports, gossip, rumors, and news.
I've seen it with my own eyes.
For the foregoing reasons, the drug policy implemented by the Vernonia School District shall be deemed unconstitutional.
I rest my case.